Florida Workers' Compensation Benefits, take one, 3, 2, 1.
Welcome to the Legal View with Farah Farah. I'm Farah, and with me here today is Mr. Bruce Feifer, an attorney in our Workers' Compensation Department. Bruce, what does an injured worker have to prove in order to receive his workers' compensation benefits?
Well, they have to prove that the accident occurred at work and that it is the major contributing cause for their current condition and need for treatment. That would be established through medical records and diagnostic studies, MRIs, X-rays, showing that the condition is new and fresh as opposed to a prior pre-existing condition.
Well, what if a lot of people, they're involved in heavy labor and maybe sometimes they have had previous back problems. What if you're injured on the job and you have a new back problem? Are you entitled to receive workers' compensation benefits in that situation?
You are entitled to receive those benefits as long as the treating physician continues to say that the work accident is the major contributing cause for why you need that treatment. Again, that the injuries are new as opposed to something that was previously existed.
What do you mean by major contributing cause? Is there a legal definition for that?
Yes, it's a doctor would have to testify that 51% or more of the problems based on objective evidence, again, MRIs, X-rays, and those types of tests are what is the cause. Unfortunately, just complaints of increased pain would not qualify to reach that decision.
What do you do as an attorney to help prove the case when there's a pre-existing condition?
We try.
The insurance company is trying to, use that to stop paying benefits.
We try to gather the medical records as early on as possible. Perhaps the claimant would need to get an independent medical exam with a doctor of their own choice to establish that these injuries are fresh and acute and new. And then it's up to a judge ultimately to decide between the evidence, which is what the cause is.
What if you're injured on the job, but you also have another part-time job that you worked on the weekends and you can't go back to that part-time job? Are you entitled to workers' compensation benefits for that also?
Yes, you are. As long as the part-time job also had you covered under the workers' compensation system, those wages would be added into what workers' comp for the first accident, for the first injury would pay.
Well, you mentioned being injured on the job. What if you're on break or you're on a coffee break and you slip and fall? Does that constitute a workers' compensation type injury?
Yeah, those would all fit under what's called the personal comfort doctrine under the Florida Workers' Compensation statute. It's expected that while you're in the course and scope that you would have a break. So as long as you don't deviate too far away from the employer's premises, that would be a covered compensable accident. So if you slipped and fell in a bathroom or in a kitchen or even walking into the building to start your workday or departing the office at night, that would also be included as a work comp claim.
Well, Bruce, thanks for your information and thanks for watching The Legal View.